absolutely. I am leading.
No, I understand.
Yeah.
So,
Unfortunately.
Yeah, tell everybody, sit down, please.
Now, this is just not fair. You really did your homework. I'm glad somebody reads it.
Yeah, people may think we're the poor sisters of the law schools, but we turn out some pretty good lawyers, real life lawyers.
So you went from law school straight to law enforcement, or was it?
No,
Oh, no.
law enforcement.
He came, I think. Nelson, what are you doing here, dear?
With the state police here in Massachusetts.
I can't just see you.
Yeah. I was going to say, excuse me, I didn't think that corporate lawyers did this kind of stuff.
I'll leave law enforcement as a fairly young man within the next couple of years.
Really?
It's another career.
Probably 50-50 between criminals.
Really? I didn't know that.
All right, guys, let's start.
Criminal appellate work also.
Oh, I didn't know that.
So it shifted.
Yeah. Nelson used to teach here. Okay. All right, we're going to start. There wasn't supposed to be a break at this point. We're going to break after the next panel. First of all, I just want to say I taught every one of those students, former students. I'm so proud. I cannot tell you. Also, this is a momentous occasion because this is probably the first time since Amherst College was founded by somebody who got sick of Williams that there has actually been an Amherst and a Williams alum on the same panel sitting next to each other making nice. So anyway, my name is Connie Rudnick. I'm a professor here at the Massachusetts School of Law. Before I came to teach full-time, I practiced at a small trial practice firm where the first 10 years of my practice was almost exclusively criminal defense work, mostly drugs and white-collar crime. My clients rarely ever confessed. But since then, I've done other kinds of stuff. So with me today, we have Professor Alan Hirsch, who we'll forgive him for going to Amherst because he now teaches at Williams. And he is an attorney, a professor, teacher, expert witness in the area of false confessions. And John Provost, another one of my former students, who is a trooper with the Massachusetts State Police and a former member of the Detective Division of that department. And we're going to be talking about the issue of false confessions. In the past 15 years, 208 convicts have been exonerated by post-conviction DNA testing. An estimated 15 to 20% of them had actually confessed to the crime. Some of these confessions contained alarmingly correct details of the criminal events. Of 125 cases in which criminologists and psychologists documented false confessions occurred, 93% of the confessors were men and 81% occurred in murder cases. The most common reason for exoneration in those cases was that another person was ultimately convicted of the crime, but frequently new scientific evidence also was the basis, either in conjunction or alone, with identification of the real perpetrator. The extent to which prevailing interrogation techniques are responsible for an environment in which the potential for false confessions flourishes has been the subject of recent debate. And our panelists are going to hopefully enlighten us on the issue of false confessions and what potentially the circumstances are that give rise to them, how to deal with them in court, and also how officers deal with the kinds of competing issues between obtaining a confession to close a case and the fear that ultimately the person making the confession may not, in fact, have been the perpetrator. So, Alan, we're going to start with you, and if you would explain to us the kinds of categories into which false confessions fall, because no one thinks that anybody who didn't commit the crime is going to confess to it.
First, thank you, Professor Rudnick, for having me here. Thank you for all the hospitality the law school has shown me in the last 2 days. With one exception, I eavesdropped on the last panel, and the splendid Boston accents just have me feeling a little out of place here. And they reminded me of a time I testified at a suppression hearing in Boston. This was a few years ago, and the judge at one point said, "I think at this point we will mock Professor Hirsch's report," which I found distinctly inhospitable. The question was about the categories of false confessions. Now, there are different taxonomies. I find, the following is what I find most useful, is to divide them into 3 categories. First, there are voluntary false confessions, which, as the term implies, someone comes forward and confesses outside of any interrogative setting. And you might think that's impossible. Who would do such a thing? Just to dispel that notion, I'll point out that when the Lindbergh baby was kidnapped, more than 200 people came forward and confessed to the crime. More recently, John Mark Carr, or you might say John Mark Carr, confessed to the murder of John Benet Ramsey, obviously a voluntary false confession. The false confessions that occupy me most, because they are more systematic and preventable, are what we call coerced false confessions. And by that, that's not a legal conclusion. Most of these weren't non-coerced in the eyes of the law. But it means that they were confessions that resulted from or came in the midst of an interrogation. And within that category are 2 subcategories. What we call coerced compliant false confessions. These are the more typical case where the confessor knows he is innocent, obviously, but confesses in any case in order to escape a grueling interrogation or to gain an implied benefit. Then there are the more rare and fascinating cases of what we call coerced internalized false confessions, where the suspect actually comes to believe he is guilty or at least has doubts about it when he confesses. So those are the 3 principal categories.
Okay. The next question is, what techniques that you have found are generally applied in the law enforcement community, even if not in Massachusetts, that create circumstances that are most likely to give rise to the coerced situations that you've named?
The most widely used law enforcement interrogation techniques all across the country are what we call the Reed technique or Reed method. You may have heard of it by that name, although it goes by other names because there are various manuals and interrogation courses, but they're all roughly the same. There are nuanced differences, but they're variations on the same theme. And they basically employ 3 techniques or aspects of the one technique. First, the suspect is isolated. That is, will be interrogated away from any kind of support system, family, friends, counsel, typically in a small windowless interrogation room designed precisely to create stress and anxiety to escape. At that point, the interrogation itself employs 2 principal techniques, what we call confrontation and minimization. First, the suspect is confronted with certainty of his guilt. We know you did it. You're not going to convince us otherwise. Often this is accompanied by the presentation of evidence, sometimes false or exaggerated. Polygraph, they're told they flunked, an eyewitness, that sort of thing. Now, confrontation is designed to communicate to the suspect the futility of maintaining innocence. We know you did it. You're in some trouble. At some point, sometimes simultaneously, sometimes sequentially, law enforcement will then minimize the crime. This can be done either directly. It wasn't so bad. you're not going to be punished severely if you confess, or more typically through implications, more subtly, with various minimization themes being introduced: provocation, justification, accident. This is just what is being communicated directly or indirectly is this is not the most serious thing in the world. Therefore, if you confess, the consequences won't be so bad. That combination, the idea that maintaining innocence is futile, but confessing guilt will bring about acceptable consequences, has been known to break down, well, let's start with the fact that it breaks down guilty people. And I often say the problem with the Reed technique is not that it's ineffective. The problem is that it's too effective. It certainly does make many guilty people confess, for which it warrants our gratitude. But it's too effective in the sense that it also breaks down innocent people.
Okay. John, you want to respond based on your training and experience to the 3 points that Alan made, which were isolation, confrontation, and minimization are parts of a generally accepted interrogation practice that are dangerous for false confessions?
I would say that certainly those aspects take place in an interrogation setting. Isolation, necessarily. There is, and I'll refer back to the last panel, as Chief Tucker discussed, there's a need to control the environment, to minimize distractions, to keep who you're speaking with on target with what you're speaking about. And so that can be defined as isolation. However, what it is a focused discussion, and it's necessary. If you have distractions, then you're not staying on track. You're not doing a proper job in investigating this situation. Confrontation, it is a matter of degree. An effective interrogation, one that you would hope is designed to get to the truth of the matter, does not just happen in a vacuum. It is not throwing a dart at a wall. You don't simply walk into a situation, to an investigation, and begin to interrogate everybody. So you have been brought, as a police officer, you've been brought into that situation, into that communication with this individual for a reason. And in Massachusetts, in particular, you need much more than just a bold-faced confession to secure a conviction. Minimization, there's quite a bit of case law on minimization, and again, I would say that's a matter of degree. You could use another word to describe it. It could be empathy. However, if you are minimizing and introducing a theory to the investigation, then you're not doing an effective job as an investigator or an interrogator. You're providing that individual with that theory to now expound upon. You've introduced that now into the environment where your goal should be to gather the truth. But however, again, I would say it's all a matter of degree.
When we talked about this earlier, we talked about the Reed technique and the other similar training, and you had a philosophy about the role that these professionals should play in an officer's in how an officer develops interrogation techniques. Can you share that with us?
A role in how Reed and...
Yeah, when we talked the other day, you talked about where you thought Reed and Zalotsky should play, the role that they should play.
Well, as an interrogator, as an investigator of criminal activity, you want to expose yourself to a number of things, even contrarian views. You want to have an understanding of what has been researched, what has been shown to be effective. But however, you have to take into account in what environments those procedures have proven to be effective. Wiklander-Zulawski was developed and I don't want to use the word perfected, but improved in a loss prevention setting, in a retail setting. The goals in that setting are different. In some ways, I discussed with a gentleman this morning, in some ways they're more quantitative. However, they don't necessarily relate to that same use in law enforcement. There seems to be a belief that the desire to clear a case will prove as a motivating factor beyond that which it is. A good investigation and a good investigator seeks the truth, not just to clear his desk or her desk and to clear it with a conviction. It's so these methods are something that you can use and at least gain knowledge about, but not necessarily rely on as if that.
So it's not
is
a
set in
Bible.
stone.
It's not a set yet.
Absolutely not. Something that you should expose yourself to, and it may lead you to pick up on certain verbal, nonverbal cues that, and I'll say this, that may, as an investigator, lead you to form an opinion. However, your opinion is really of no consequence. Your opinion simply does not matter. What you are, as best you can be, is an objective fact gatherer. And whatever your personal opinions are that lead you to gather those facts, it's not an appropriate evaluation. It's not something that you should appropriately be interjecting into the situation.
Ellen, I assume that you haven't found that that's the approach of all law enforcement throughout the United States.
One of my rules of thumb in life is never to argue with someone who carries a gun.
I sent an email and asked them all to please leave their guns behind today.
John has made several references to the law enforcement's role and motivation for or towards gathering truth, and that's obviously what it should be. But I think this leads to one of the real problems in this area. My colleague at Williams, Saul Casson, who is probably the world's leading authority on confessions, describes what for him was a breakthrough moment, an epiphany. He heard one of the gurus of the Reed method give a talk expounding all the wonders of the method for eliciting confessions, and in the Q&A somebody said, well, that's all great. It sounds like a very potent interrogation technique, but aren't you concerned that it will also break down innocent people? And the man with painful candor said, no, because we don't interrogate innocent people. Beneath the veneer of humor, there is a powerful truth, which is it's an important part of the Reed technique to screen and figure out who is truthful before you begin the interrogation. So John's absolutely right. Law enforcement sees itself as aiming at truth when they interrogate people, but at least those people who follow the Reed method strictly, and John can speak for himself and his department, obviously not everybody does, but they have an interview process which takes place before interrogation to see whether interrogation will be resorted to. And what's central to this process is observation of body language and response to verbal cues. So some manuals will spend 100 pages on figuring out whether a person is truthful by their posture, and they will have diagrams. So if I'm like this, you know I'm speaking the truth, but you better be suspicious if I slouch a little bit. Things like that. There's only one problem with this. It's hooey. That is to say, study after study debunks the idea that humans are good lie detectors. Maybe someday we will be, but we're just not. You could flip a coin and you will be as accurate as people are in figuring out from body language and verbal cues whether someone is telling the truth. And the sad thing is, trained professionals, this has been studied too, they're no better than the rest of us, or a tiny bit better. The only difference is they're much more confident in their what amounts to guesswork. So if that's the screening method, and that's the way of ascertaining whether you'll be gaining truth by interrogating someone, you have a system that is doomed to failure. You have people who are presumed guilty based on a process that amounts to guesswork, and then subject to an interrogation process which is known for and designed to break them down.
John, what about the issue of cues that you can take from a person's appearance, psychological makeup, physical appearance? How I assume that those are relied upon by law enforcement, and has your experience told you that, in fact, you could be the star of Lie to Me?
I could be the, excuse me?
Oh, you don't watch Lie to Me.
No.
It's a human lie detector on TV, a guy who can apparently tell, he and his group can tell everybody who's lying and not lying merely by their facial expressions and related posture and things like that. What's your experience?
Well, I can say to you this, that my wife won't watch the news with me because she's heard me too oftentimes with language that I won't repeat here say, that individual's not being truthful. Of course, it's not under those circumstances. And that's my opinion. That is strictly my opinion. And as an investigator, there are things that I have seen that cause me to believe that, okay, I am talking to this individual, whether it be in an interrogation setting or in it can switch. You may find yourself in an interview and then find yourself confronted with someone who gives you one of these cues that you pick up on. Police officers oftentimes will talk about, you'll hear about their sixth sense, which I would, in using Professor Hirsch's terminology, would say is hooey. We don't have a sixth sense. What we have is a desire to pay attention to detail, to pay attention to the surroundings that we find ourselves in, to pay attention to how you sit, what that tells me about what you think about what I'm saying, whether or not you maintain eye contact with me. I oftentimes in the classes to the recruits that I teach talk about a series of bank robberies that I was one of the police officers involved investigating, and the individual who was eventually convicted of it was on his fourth or fifth bank robbery. It was about a 95-degree high humidity day in July one summer, and he walked into a bank wearing a scarf around his neck and a knit hat and winter gloves and a trench coat, and he stood in line for 13 minutes in the bank waiting for the next available teller. Every person in the bank, every teller in the bank, and even the manager doing his paperwork behind closed doors saw that individual and felt intimidated by that individual. And we interviewed them all individually, and more than 70% of them, I'm picking a figure, but a majority of them all came to the same conclusion that that individual must have had some type of skin condition. Well, a police officer in that same situation says, baloney, hooey. He's going to rob the bank. It's an observation. It's an observation. There are a number of different things. Now, again, that's my opinion. My opinion is that he's going to rob the bank. My opinion is that she's not at all interested in what I'm saying. Okay? It's my opinion. I am but one part of the process. I'm there to gather information. If I offer my opinion as to whether or not I am right about my observation, it's inappropriate. There's no place for it. But if I ignore my opinion as I'm gathering the information, then I'm not doing my job either.
I'll have questions at the end, Sue. Alan, part of when I was doing all the research I did a couple of TV shows with Saul many years ago, and refamiliarizing myself for the panel. I was taken with a number of confessions that were extraordinarily detailed, many of which contained information which the police said had not been made public. And quite frankly, as much of a skeptic as I am, if I had heard all this information and the police got up and said, we never let it be known that the person was tied with yellow wire as opposed to any other kind of wire, and he offered the answer that he tied them with yellow wire with his hands behind the back, I would say, who else would know this besides the person who committed the crime? So can you address how those who've studied this have concluded that people get this information and what can be done to perhaps avoid it?
That's a great question, and I'll start with an anecdote, a case I was involved in. I just should say by preface, maybe I'm becoming too cynical with age and with experience, but increasingly I find that the more detailed the confession, the more accurate details there are, the more grounds there are for suspicion rather than confirmation. So one story, a case in Missouri in which someone is accused of a rape, arson, murder in a house which by all accounts they had never seen. And the details were that the person supplied of the house. Can you describe the house? The person was in the house, presumably in the midst of a rather crazy adrenaline rush during which they were committing multiple felonies for just several minutes. And he was describing, I will remember this, I'll get this verbatim, the knickknacks and figurines on the dining room table. He described the stereo was over here and the bookshelf over here, and I've just got to tell you that he described his house in more detail than I could describe the house I've been living in for 10 years. Now, this is someone with an 8th grade education, and so far as anyone could tell, not a photographic memory or any other unique skill. So on the surface, the premise behind Connie's question is right there. How could this person possibly not be guilty if they could accurately describe this house? But when you begin to think about it, you ask, how could they possibly describe it with that degree of accuracy unless they had been supplied some of the details? Now, I want to take a step back and say I could pass a polygraph by saying I am not a cop basher. I thank God every day that people like John are out there risking their lives to keep the rest of us safe. It's absolutely true. I am, though, a constructive critic of law enforcement. And very often, usually inadvertently, they supply the suspect details of the crime during questioning. In this particular case, it happens that they had shown a house plan to the suspect and talked about the house. They weren't doing it because they wanted him to spit back these details to prove the confession false. That may happen, but that's obviously the exception. That's unprofessional. They were doing it to jog his memory, to test his reactions, all those sorts of things. Be that as it may, they were the source of the information he would spit back at them. So I think that's the short answer to your question, is you get detailed confessions in which the details were supplied in the process of interrogation, in the process sometimes of going to a crime scene, and so forth.
John, how, if that is the case, how can police officers minimize the inadvertent disclosure of information which would assist somebody who did not commit the crime in incorporating details into a confession, which is going to make anybody on the street think that in fact they did?
Well, it's the role that's our purpose in any investigation, or at least any significant investigation, is to minimize the amount of information that gets out there, and for those obvious reasons. When I was in the detective unit, I worked in a district attorney's office, and the district attorney at the time was much maligned for his unwillingness to appear on the 6 o'clock news. We joked about it oftentimes. But as a police officer and as an investigator assigned to that detective unit, we greatly appreciated it. It helped us to contain things. It didn't do much politically for him, but it helped us quite a bit. Obviously, again, I'll go back to it's a human endeavor. You try not to allow that information to get out, and you try to objectively recognize whether or not you've been successful. However, a confession, an accurate confession, is not necessarily the only goal of having that individual continue to talk to you. Just having that individual continue to talk to you can provide you with information that you know to be inaccurate, but that is going to prove to be problematic for that individual later on in a prosecution, because you have other information that lets you know that what he's saying, or that you believe you can prove that what he's saying is a lie. So sometimes just having them talk to you, as long as they're talking, truth can be just, the lies can be just as valuable as the truth. And whether, again, I'll say, whether or not I am accurate in my opinions as to what is a lie and what is the truth, I will say is inconsequential. It's not for me to determine. I am not the judge, jury, and executioner. I'm not the trier of fact. I'm the gatherer of fact. The trier of fact, their job is to determine whether or not the facts that I have gathered are credible, are reliable.
Alan, let me ask about a topic that was raised in the first panel, and that is misrepresentation, lies, and deception. What role do they play in the potential for false confessions?
Yeah, the false evidence ploy is deadly. And the United States Supreme Court has given its imprimatur. They didn't actually say that law enforcement should lie to suspects, but they said that that will not per se result in the suppression of a confession. That will be part of the totality of the circumstances analysis, which, as some of you know, is more or less synonymous for the confession will not be suppressed. When a person is told that he has flunked a polygraph, when he's told that there are eyewitnesses, when he's told that there's a DNA match, what is the obvious response? Well, one response might be, no, it can't be. But another response, especially when you're being interrogated in conditions designed to create anxiety, stress, despair, and even desperation, might be, oh my God, I'm in deep fill in the blank. And it's simply an empirical matter. It's not open for dispute. The presentation of false evidence has induced false confessions. So I think that's a very troubling matter.
John, the issue of inducing confessions with either overtly or inferentially false information. We've got your co-defendant, and he confessed, and he said it was all you.
Well, again, I would say it's a matter of degrees. However, and I know Chief Tucker had mentioned this in the previous panel, and I'm not sure if we touched upon it yet. I believe so. I believe, as an investigator, if you're introducing a theory into the case, you're not doing your job. You're going to set out to prove that theory, whether you know it or not. I've been involved in investigations where the round table before it wraps up involves just that type of discussion, 2 or 3 different theories. One of them may be right on, but if you introduce it into the situation, then, again, whether you know it or not, you're more likely to set out to prove it. The investigation should be more of a roadmap. Now, Chief Tucker discussed, lobbied off some examples as he tried to get John Morris in a bit of a bind in the last
I think
panel.
we drove John right out of the building.
But I would say words matter. in what is it that you're implying. I believe it was his first example. Would there be any reason why, if there are security cameras around that gas station, we would see you at 9:30 o'clock, or 9:30 p.m., excuse me, entering that store or entering that building? Have you introduced a theory there? No. Have you even indicated that there are security cameras? No. But have you got them starting to think, geez, well, there's a bank there. And Reed or Wickland or Zulawski might say, oh, now he's looking up and to the left. Well, whether I put any value in that, but now he's starting to think. And now he may tell you, well, I shopped there on occasion. I don't think I was there that night, but maybe I was. And you can go and explore that. But have you implied anything in that situation? Maybe. We're a room full of, I'd say, mostly attorneys, so if not all, we pay attention to the details. Is the individual that you're floating that idea out to paying attention to all those details, or is he hearing, they got me on camera?
Also, we presumably, since most of the people in this room are attorneys, or at some point in their lives were attorneys, they have IQs above dull normal, and that's not necessarily true when you're interrogating suspects, and some of them are individuals whose psychological makeup makes them more likely to fall for something that you say is merely inferential, and in fact it is inferential. And certainly you're not psychologists, so how can you tell whether somebody is likely to get lapped up by even an inference? If we found your fingerprints in that building, could you explain how they got there if you weren't there to kill the victim? People who have very low or marginal IQs and psychological issues, neither one of which you probably as a police officer can readily discern. How do you deal with that?
Well, if you're dealing with a dimwit, or however it was that you just referred.
I didn't call him that, John.
Dull
normal. It's
dull.
It's an identified IQ level.
Okay, but I would say that we're on the periphery there, much like the Bram decision that Judge Agnes has written about and Professor Hirsch has as well. Bram held that any form of coercion should induce or should trigger a decision that what followed is not reliable, is not admissible. And maybe I'm muddling the holding there a bit. But Bram dealt with a situation where the coerced confession was obtained by a slave owner against his slave. There, again, we're dealing in degrees. I'm not, and I'm not trying to get personally offended here, but what I'm saying is I am not, nor is anybody that I have ever worked with, akin to a slave owner. I have never sat across the table from someone, even the most horrific person that I have sat across the table from, and dealt with him, and he, in turn, dealt with me as if he were my property. And in reading Professor Hirsch's law review article on that, the first thing that drew to my mind is it's not an analogous situation. There's no analogy there. If you're dealing with a 14-year-old whose 12-year-old sister was brutally stabbed to death, sexually assaulted, and is now dead, and you are in the aftermath of that, investigating it, and you apply, I'm trying to choose a word, heavy-handed investigative techniques on that 14-year-old, of course what you get you can't rely on. Of course. There's no argument in that. But if you're dealing with a 35-year-old who has packed groceries his entire life in between periods of unemployment and living in his mother's basement, those are all factors that you take into account. And those are all factors that the jury can take into account as well, without the need of any type of expert opinion to explain to them what they know they're seeing.
Okay, the last question I'm going to ask, and then we'll take questions from the floor. Professor Hirsch has been an expert witness in a variety of different venues on this issue, and it is sort of this decade's battlefield, the question of whether false confession experts can testify either at motions to suppress or at trial concerning reliability techniques, et cetera. So to finish up this part of the program, Alan, will you tell us about your experience,
Sure.
where you think the law is going,
Yeah.
and what we can look for in the future? And there are law review articles that detail this state of the law.
Yeah, so at least from my perspective, seeing as the courts have given their imprimatur to interrogation techniques that we know are risky, the least they could do is allow experts to educate the jury about these interrogation techniques, about what's known about false confessions. And in many jurisdictions, they do. And in most jurisdictions, it's up to the trial court. Many do and many don't. But let me just briefly touch on those which don't. They advance two reasons why people like myself cannot be allowed to poison the minds of jurors. One is that this is insufficiently scientific. The field, what we know about it, the literature, essentially it's too speculative. What we have to offer is just not known with sufficient confidence. And the second reason is that I think John sounds like he endorsed the second reason, which is this is all a matter of common sense. Jurors know that people confess falsely. Now, you'll note a slight tension between these two reasons. One might say a contradiction. It's either that it's not sufficiently, we don't have a sufficient reason to be confident in it, or everybody knows it. Well, either of those could be true. They can't both be true. It is extremely important that experts be allowed to educate jurors in this area. Just very quickly, one more statistic. In cases of proven false confessions, these are cases usually by virtue of DNA, but some way or another, we know the person was innocent. Cases that went to trial, in 80% of those cases, juries convicted. And this is because, in fact, this is not only because, but it's largely because it is so counterintuitive to people that an innocent person would confess to a serious crime. So to my mind, it's very important to, not just for personal and professional reasons, but for reasons of justice, to allow people like myself to testify.
Are more courts allowing it, and under what circumstances, and what degree of proof has the defense attorney been able to offer to get you to testify?
It's all over the map. I've been very fortunate in Daubert hearings and have won most of the ones I've been involved in, but courts are all over the map. And even in the blue progressive state of Massachusetts, the SJC has frowned upon confessions expert testimony. So it's all over the map. It's a great law review topic for some of you students out there.
Okay. Let's have some questions. Are there any questions from the floor? Gentleman in the blue. Yes. Why don't you, can you stand up so everybody can hear, please?
Can you give us any of the data or study as it relates exclusively to the Commonwealth of Massachusetts concerning this phenomenon?
I don't have state-specific data. I might take the occasion to plug my website. Truthaboutfalseconfessions.com will give you a whole long literature, which will include some articles that have the closest data to your purposes.
I read a lot of articles for this, and I have not seen anything that it goes on a state by state. The Innocence Project is another place that does have data, and their website, and there are innocence projects at law schools throughout the United States, and they may have on a state by state, but I'm not aware of any.
Such as videotaping of interrogations? Corroboration of confessions before you can have a conviction, but in terms of the introduction, I'm not sure.
Sandra, you had the...
This is a question for John. Do you tailor your techniques any when dealing with someone who may be perceived of having a mental health condition? And if you do, how do you do it?
I don't think there's a definitive answer to the question, but you obviously, whether or not whatever the person's individual characteristics may be, maybe they're extremely elderly, maybe they've been injured in whatever the act is of the crime that you're investigating. Maybe they're heavily intoxicated. Maybe they are the 14-year-old boy who stabbed the 12-year-old girl. Or maybe they're, I'll remember that term on the third time, dull normal. Maybe they're dull normal. Obviously you're going to tailor it, and obviously it's going to be a factor. And it should be a factor for the trier of fact as well. But it's certainly a factor for the investigator as the gatherer of the facts.
Okay, we're going to have like a 5-minute break